Good afternoon, everyone, and welcome to the Legislative Operations and Elections. Committee Secretary, please call the roll.
Assemblyman DeLong.
Present.
Assemblywoman Dickman. Here. Assemblyman De Silva. Here. Assemblywoman Gonzalez.
Here.
Assemblyman Hibbets. Here. Assemblyman MacArthur.
Here.
Assemblywoman Brittany Miller.
Here.
Assemblyman Cameron Miller.
Here.
Assemblywoman Monroe Marino.
Here.
Assemblywoman Newby.
Here.
Assemblyman Yeager.
Here.
Chair Gorlow.
And I'm here. Thank you very much. Welcome again to the Assembly Legislative Operations, Operations and Elections. I got my head all around the softball game that's tonight. And I'm going, yeah, that's going to start in about an hour and 10 minutes. Go Assembly. I'm not playing, thankfully. Y'all hurt me in 2019. I don't play anymore. I did. So anyways, quick, we're going to do a quick little bit of housekeeping. Basically, be nice to each other and turn off your electronics. When you're going to testify, push the button. Sometimes you got to push it 2 or 3 times. It's a little finicky. State and spell your name for the record, and then turn it off when you're done testifying. We are going to start today's agenda with our work session, SJR 7 of the 81st legislative session, not to be confused with the other SJR 7. And with that, I will turn it over to our policy analyst.
Thank you, Madam Chair. Haley Prohl, Committee Policy Analyst. The only measure on work session today is Senate Joint Resolution 7 of the 81st session. This was heard in committee on May 4th. It proposes to amend the Nevada Constitution to remove the constitutional provisions governing the Board of Regents of the University of Nevada. The legislature shall provide by law for the governance of the university and the establishment of its various departments. In addition, the resolution stipulates that proceeds of public lands donated for the support of the institution shall be invested by the state of Nevada as required by law. And there are no amendments. Thank you, Madam Chair.
Thank you very much. Committee, do I have any questions? Okay, seeing none, I'll entertain a motion to do pass.
So moved.
And a second?
Second.
Okay, I have a first from Vice Chair Miller and a second from Speaker Yeager. Any discussions on the motion? Okay, seeing none, all those in favor say aye. Aye. Any opposed, nay?
Nay.
Please raise your hand for the nays. Okay, I've got Assemblywoman Dickman, Assemblyman DeLong, Assemblyman MacArthur. Is that all? Okay, motion carries. Thank you very much. I will now close the work session, and we will now open. Oh, floor statement. Let's go. Kasama was co-print. Let's do Kasama then. Thank you. We will move on to Senate Bill 60, and we will open the hearing for that. This measure revises provisions relating to elections. I will call forward the bill sponsor presenter, Secretary of State Aguilera, and Deputy Secretary for Elections, Mark Lashin. And you may begin when you are ready. Thank you very much for joining us.
Good afternoon. Cisco Aguilar, Secretary of State. For the record, with me I have Deputy Secretary for Elections, Mark Velashin. Thank you to Chair Gorlow and members of the committee for your time as we present SB 60. This bill was initially brought by Secretary Barbara Sagaski and is intended to clean up our election statutes. Nevada's elections have changed through each session, and we need to keep up with the times to make our laws clear and straightforward for counties and constituents. We know that there are often debate on issues related to elections, but this bill is nonpartisan and has been created with recommendations from the clerks across the state. The goal is to alleviate administrative burden and clear up any confusion to help county and state workers navigate the law to continue running secure, fair, and transparent elections. Now I'll hand it to my Deputy Secretary for Elections, Mark Velashin, to go through provisions of the bill. Thank you.
Good afternoon, Chair Gorlow, members of the committee. Mark Velashin, Deputy Secretary of State for Elections, for the record. The cleanup bill before you today proposes several changes across Title 24. I apologize that it is a bit lengthy, but I have summarized the provisions and want to make sure I address each in case you have questions. SB 60 starts with a proposal to reintroduce a statute that was repealed during the 2021 legislative session relating to the ability of the county clerks to issue a replacement ballot in certain situations. The provisions covered by sections 1.5 and 7.6, though, may be amended further. The next proposal relates to the recent passage of the Electoral Count Reform and Presidential Transition Improvement Act of 2022, referred to as the ECRA, which was part of an omnibus appropriations bill passed in the last days of the 117th Congress. There are numerous changes in the ECRA, but an analysis conducted by the Elections Division in conjunction with our Deputy Attorneys General identified two significant changes that make up this recommendation. The first is to clarify who will submit the certificate of ascertainment. Existing state law suggests, but does not specify, that the Secretary of State will do so. While this has been our historic precedent, it should be clear in statute. Section 11.7 clarifies and codifies this change. The second, more complex proposal relates to the new timelines under the ECRA for the selection of presidential electors. Our current timelines for canvass, recount, and contest do not line up with what is now required by the ECRA for the selection of the presidential electors. In 2024, for example, we must certify our presidential electors under the new requirements of the ECRA by December 11th, 2024. But we could still be conducting a recount or challenge, which under existing law could extend through the end of December. That difference in the timelines must be reconciled, or we risk a significant issue after each presidential election. Section 1.7 establishes a different timeline for filing a recount or an election contest that applies only to the election of presidential electors. Along similar lines, the existing timelines for a non-judicial candidate to file for office, withdraw, and the statutory challenge period have led to significant voter confusion because the timelines do not allow the process to go through the courts in time to remove an ineligible candidate from the ballot. As a result, voters see candidates on their ballots who have already been declared by a court as being ineligible. This occurred twice during 2022. Section 6.5 proposes to address this by requiring a court to set a contest of an election for hearing not more than 5 days after the filing of the statement of contest for any election. Existing law provides the text of the declaration of candidacy for partisan offices, but it does not apply to an independent candidate, as it has a specific line stating the candidate's party affiliation. Section 1.8 of this bill creates a declaration of candidacy for an independent candidate for partisan office that omits any reference to a political party. Existing law allows the payment of a candidate filing fee to be done by cash, cashier's check, or certified check only. Section 2 allows that it may also be paid by credit card if that option exists at the filing office. Of note, it would not require any filing officer to accept a credit card payment, but rather those that are able to could accept that form of payment. Section 2 also clarifies the filing fees in order to make some of them more understandable. The only new fee on the list proposes to clarify that all presidential candidates must pay the filing fee of $250. NRS 298.109 currently only requires independent candidates for the office of the President of the United States to pay the $250 fee. This proposed change will standardize that for all candidates, same as our other fees for statewide and federal offices. Existing law provides that members of an election board serve from the day before the day of the election until the time for filing contests of the election has expired. Section 3.5 of this bill provides instead that members continue to serve from such from the first day of appointment, which may be weeks before the day before the election. Sections 4, 8, and 12 to 17 of this bill provide that for the purposes of determining the majority of the votes cast in a primary election for an office for which voters may select more than one candidate, each ballot upon which a voter marked a valid choice for one or more candidates for that office shall be deemed to be one vote cast in the primary election for that office. This situation came up during the 2022 election cycle. Lander County had a school district race where 7 candidates were on the ballot for 3 seats. Existing law allows that if one candidate receives 50% plus 1 vote during the primary election, then that candidate is declared elected and will not appear on the general election ballot. But with voters being able to pick up to 3 candidates in that race, it was not clear as to how to determine if anyone had received 50% plus 1 of the votes. This proposed change would address that confusion in Lander County as well as in other jurisdictions that have similar provisions and who could potentially see similar confusion. Existing law provides that every ballot with the names of candidates for any statewide office or for President or Vice President of the United States must contain an additional line in which the voter may select none of these candidates. The statute, though, specifically calls out that the line have a square next to it, whereas we have only used ovals or circles on our ballots for quite a few years. In fact, I could not find an example of the last time we used squares instead of ovals on our ballots. Section 5 of this bill proposes to change the word square to the word space for uniformity. The 2 proposed changes relate to risk limiting audits. The many pilot risk limiting audits we have conducted following statewide and primary general elections and local special elections have informed these two proposed changes. The first is a proposed change in the timeline to ensure that there is time to do a risk limiting audit properly. Of note, the proposed change will still enable the results of the risk limiting audits to inform an election challenge under the statutory timelines. The second proposed amendment is an allowance in NRS 293-391 so that it would clarify that in conducting a risk limiting audit, clerks and registrars are authorized to use voted ballots and other records that would otherwise be secured in the vault of the clerk. These changes are codified in sections 6.25 and 6.3. Existing law provides that the deadline to register to vote at the voter registration agency, the Department of Motor Vehicles, or an automatic voter registration agency is the last date to register to vote by mail. Sections 6.6, 6.75, and 17.7 of the bill require a voter registration agency, the Department of Motor Vehicles, and an automatic voter registration agency to notify a voter who registers to vote after this deadline that in order to vote in the upcoming election, the voter must still register to vote by computer or at a polling place for early voting. We are still considering additional methods to adjust this requirement to better support the registration of eligible voters. Existing law requires the Secretary of State to prescribe the form for applications to pre-register or register to vote. Section 6.65 of the bill requires an application to register or pre-register to vote to include an option for a voter to elect not to receive a mail ballot. Sections 6.7 and 6.9 are a minor adjustment to approve our list maintenance process that would allow a clerk or registrar to update a voter's registration using information received through the National Change of Address or NCOA program. That is currently allowed, but NRS 293.5307 requires a notice to be sent to and confirmed by the voter before that change can be implemented. This change would give the clerks and registrars the option to implement certain changes and then send the notice to the voter afterwards. Section 6.8 proposes to amend the provisions relating to the threats to our elections infrastructure, proposing to make NRS 293.755 more inclusive. Right now, it is only a crime to tamper with, interfere with, or attempt to tamper with or interfere with a program or machine used to counting ballots, or a tabulator. This change would expand it so that it covers all programs and systems used in the conduct of an election, such as voter roll databases, election management systems, check-in kiosks, and others which are critical to the process. Section 6.9 proposes to amend NRS 293.810 so that a person is prohibited from being pre-registered or registering to vote in more than one state at a time, while existing law prohibits a person from being pre-registered or registered to vote in more than one county at a time. That is already addressed through our current list maintenance processes, but this change would further enable the prosecution of individuals who knowingly were registered in multiple states with the intent to vote in more than one. Section 7 requires the Secretary of State to adopt by regulation a cyber incident response plan specifically for elections. It also requires a county or city clerk or other election official to notify the Secretary of State of any cyber incident or attempted cyber incident in accordance with the cyber incident response plan. NRS 293.875 already requires immediate notification of any cyber attack or attempted cyber attack, but the development of the cyber incident response plan would provide additional clarity for election officials as to what needs to be reported and when. Section 9 of the bill requires a withdrawal of candidacy by a candidate for a city office to be presented within 7 days as opposed to the current timeline of within 2 days. This change will make the withdrawal period for candidates for city office consistent with the requirement for all other candidates. Section 11 revises the definition of uniformed service voter to include a member of the active or reserve components of our newest branch of the U.S. military, the Space Force of the United States. Section 11.3 proposes to amend special elections into the statute in NRS 294A that covers the campaign contribution limit. NRS 294A 100 addresses primary and general elections and special elections specifically for a recall, but not a special election to fill a vacancy. This change proposes to address that omission. Section 17.5 proposes to extend the implementation of provisions of Assembly Bill 432 from the 2021 legislative session to January 1st, 2025 in order to align with the timeline for transition to a top-down voter registration system. Section 19, finally, proposes to repeal certain outdated provisions, specifically NRS 293.365 and NRS 293C.365, which require that no county board in any precinct, district, or polling place in which paper ballots are used may commence to count votes until all ballots, used or unused, are accounted for. One can see how the legislative intent of this statute from the 1960s was to ensure that, if 200 paper ballots were issued, before starting the tabulation, accountability of all 200 ballots would be made. Given how elections are conducted nowadays with mechanical voting devices and mail ballots, this statute is no longer applicable. NRS 293.423 states, "At the hearing of any contest, the ballots may be opened and a recount made in the presence of parties or their representatives of the votes cast for the various candidates for the contested office." There are other statutes in place that describe the process for a recount in an election contest that allow for the complexity of how elections are administered nowadays. It simply would not be possible to, quote, "open ballots," unquote, and conduct a recount during a court hearing of an election contest, particularly since NRS 293.404 subsection 3 requires that during a recount, quote, "all ballots must be recounted in the same manner in which the ballots were originally tabulated," end quote, which means the use of mechanical tabulators. NRS 293.567 requires the county clerk to transmit the number of registered voters in the county and their political affiliation to the Secretary of State before certain elections. The intent of the statute was to have a final number of registered voters in each county before Election Day. However, with same-day voter registration, the actual voter turnout and number of registered voters continues to change up to the close of polls on Election Day. This information is very important to the county and state election administrators, and we will continue to get it in order to determine the percentage of voter turnout. But the statute requires this information to be compiled and sent no later than 4 days before Election Day, so it is not an accurate depiction of our registered voters and is inaccurate almost upon submission, as other voters continue to register up to the close of polls. Thank you for your patience. This concludes my presentation. I will remain available for your questions.
Thank you very much for your presentation. Committee members, any questions? Someone's got to have a question. Okay, Assemblywoman Monroe Moreno, please go ahead.
Thank you, Madam Chair. And I just have a question about the amounts that are listed on page 13 and 14 of the bill. The trustee of a county school district, hospital, or hospital district is at $30, and the member of the Board of Regents of the University of Nevada is at $0. Can you tell us how those amounts, how you came up with those amounts for those positions?
Thank you for the question, Assemblywoman Mark Velashan, for the record. With the exception of the change in fee for candidates for U.S. President, all other fees were already in existing statute and have not been touched or amended.
Thank you for that. Can you tell us why they're so low in comparison with the others? What the reasons that were made? Whether you were there when they were made, or do you know why?
Thank you for the question, Assemblywoman Mark Velashan, for the record. We will look into that, and I will get you some further information.
Thank you.
Thank you very much. It is interesting that apparently a United States Senator is also lower than the president. Interesting. We'll go next question to Assemblyman DeLong.
Thank you, Chair. You had a specific term you used with regards to an audit. I'm not finding it in here, but can you describe what that audit is? And then also, it sounds like you'd mentioned there are more amendments coming. Did I interpret your comments correctly?
Thank you for the questions, Assemblyman Mark Velashan, for the record. First, the term I used was risk limiting audits. A risk limiting audit is a type of audit that was put into statute in 2019. We've been doing pilot risk limiting audits. It's a statistical analysis of the results, and there's a few different ways that it can be done. I will also provide more information on the process after the committee. And then your second question in regards to the amendments, even in the last 24 hours, yes, there were some ideas raised that may be beneficial and worthy of consideration. Not ideal in timing, but it's certainly something that has come up, and the goal is to make them correct and not necessarily rushed. So that is a possibility.
Did you need a follow-up, Assemblyman? Okay, great, thank you. Any other questions? Okay, I have a quick question. In section 1.5 talks about a registered voter may submit a written request, and then it goes on because of an illness or disability. I'm just thinking about when my own mother ended up in the hospital. Can you explain a little bit more about what that written request is? Is there something they could do online? Because I'm not so sure she would have been in quite a state to actually write out a letter.
Thank you for the question, Chair. Mark Velasquez for the record. Understand entirely what you're talking about. This statute had been in place in years prior. Most folks aren't aware of it, and usually what ends up happening is that somebody would show up to the clerk or registrar's office, identify a spouse, family member that has been hospitalized or otherwise unable to receive a ballot or can't find it. And this statute authorizes a clerk or registrar to cancel the previous one and then issue one upon essentially a statement with the signature and a little bit of other information about the reason why. This is one of those provisions that we are looking very closely at and believe we may have an alternate solution for as well that would reduce the need for that sort of form, but that would still provide a secure manner for a voter to be able to cast a ballot during an election.
Thank you very much. Last call committee for questions. Okay, seeing none, we will then open up a testimony in support of SB 60. Please come on up to the table. Remember to press the button maybe 2 or 3 times. And state and spell your name for the record. You may begin when ready.
Good afternoon, Chair and members of the committee. For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We are here today in support of SB 60. We are happy to see the modernization of how candidates can pay filing fees by being able to use a credit card with this bill. The extension of counting mail-in ballots also ensures every single vote is counted and that the process is accurate. Finally, we also appreciate the added language around cybersecurity. Nevada is already a leader in secure elections, and this will put us further ahead and make our elections even more safe and secure. Please support SB 60. Thank you.
Thank you very much. Is there anyone else in Carson City who would like to testify in support of SB 60? Okay, seeing none, we will go to Las Vegas. And please press the button when you're ready to speak and then turn it off so we don't get some reverb back. And state and spell your name for the record. You may begin when ready.
Good afternoon, Chair, members of the committee. My name is Melody Hudilia. That's spelled MELODYJUDILLA, and I'm the Deputy Director of Silver State Voices, which leads the Let Nevadans Vote Coalition. On behalf of the coalition, I am here to express our support for SB 60. We applaud the efforts of the Secretary of State's office in prioritizing security and taking measures to improve our voting process. Nevada's elections are safe, accessible, and secure, but we should always be looking to improve our elections when we can, and SB 60 does just that. We also appreciate the attention given to smaller yet significant changes. For example, the changes in allowing candidates to pay their candidacy fees with a credit card. The Secretary of State and their office know the ins and outs of election administration, and we support measures that improve their workflow and therefore Nevadans' election experiences. We urge this committee support SB 60. Thank you.
Thank you very much.
Good afternoon. Apologies. Good afternoon, Chair and members of the committee. Happy Thursday. For the record, my name is Aria Flores, ARIAFLORES, and I am here on behalf of Chispa, Nevada with the Let Nevadans Vote Coalition, and we are in support of SB 60. SB 60 not only streamlines administrative processes, but more importantly strengthens our cybersecurity infrastructure to protect the very foundation of our democracy. This bill, particularly Section 7, Subsection 2, addresses a significant gap in our current system by mandating the Secretary of State to opt a cyber incident response plan for elections and ensuring compliance from all county and city clerks as well as local election officials. This bill would require any cyber incident or attempted cyber incident to be promptly identified and reported to the Secretary of State. By supporting this bill, we will send a message that we are committed to preserving the integrity of our electoral system. But it is important to note that prior to SB 60, there was no legislation that specifically addressed the need for a cyber incident response plan within the Secretary of State's purview. Without a plan, it leaves our election system vulnerable and disruptive to cyber threats. With no established framework to swiftly and effectively counter such incidents, SB 60 is a proactive strategy to combat any interruption or tampering attempts in our elections. I encourage you to support SB 60. Thank you for your time.
Thank you. Next person can begin when ready.
Good afternoon, Chair and committee members. My name is Carrie Durmick. That is Kerrydurmick, and I'm the Nevada State Director at All Voters Local Action and a proud member of the Let Nevadans Vote Coalition. SB 60 would allow candidates to pay their filing fees using a credit card. By allowing candidates to pay their filing fee with a credit card, it would provide more convenience to any candidate who wants to file to run for office. SB 60 would also require that the Secretary of State's office adopt a cybersecurity incident response plan for elections that each Nevada election official has to follow. That this provision further protects Nevada voters and our election officials from cybersecurity attacks. SB 60 is a common sense election administration legislation that clarifies and cleans up several Nevada election statutes that will only benefit election officials and voters in the future. I encourage the committee to support SB 60. Thank you very much.
Thank you. Is there anyone else in Las Vegas who would like to provide testimony in support of SB 60? Okay, seeing none. Broadcasting, is there anyone on the telephone?
To testify in support of Senate Bill 60, please press star 9 now to take your place in the queue.
Thank you, Chair and committee members. I'm Dayla Gibson, Daela Gibson. I'm representing Planned Parenthood Marmonte as part of the Let Nevadans Vote Coalition. We support this bill and ditto other supportive testimony. Thank you.
Thank you. Next caller, please.
Good afternoon, Chair and committee members. My name is Jessica Munger, Munger, and I'm the program manager of Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization, and we are in support of SB 60. Thank you for your consideration.
Thank you for your testimony. Next caller, please.
Hello, everyone. My name is Davis Hushkon, DAVISHUSKON. I am the Executive Assistant for the Las Vegas Indian Center, and we are in support of Senate Bill 60. We believe that it will provide a better, efficient, and more thorough outcome for those that vote and for those officials that make what happens in Las Vegas. Thank you.
Thank you. Next caller, please.
Chair, there are no other callers to testify in support at this time.
Thank you very much. With that, we will close testimony in support, and we will open up testimony in opposition. Is there anyone in Carson City who would like to come to the table to testify in opposition of SB 60? Okay, please go ahead when you're ready.
Madam Chair and Committee, my name is Lynn Chapman, and I'm the State Vice President of Nevada Families for Freedom. Section 1 of SB 60 addresses the situation where a voter is forced to leave their home for such reasons as illness, disability, or emergency, and indicates that this is a situation in which a voter would need to apply for a replacement mail-in ballot. It further outlines the administrative and legal steps and a long list of personal information that would be required of the voter. Someone will help the voter receive the receive and submit the replacement ballot to the county clerk. All this in addition to the voter's already stressful situation. If a person leaves home for the reasons outlined in Section 1 and they've already received their mail-in ballot, they could either take it with them or they leave when they leave, or have someone bring it to them after they've gotten to wherever they needed to go. Likewise, if their mail-in ballot arrives after they've left home, someone could retrieve the mail-in ballot and bring it to the voter just as easily, if not easier then, they can bring them a replacement mail-in ballot and without the need for all the administrative and legal steps and data required. The existing NRS 293 2699-19 already covers having someone mark and sign a ballot for someone who can't do it for themselves. And the existing NRS 293, 2699, 23 already covers having someone return the mail-in ballot on behalf of the voter. The creation of a new statute for this scenario is unnecessary. It is already addressed in existing statutes, and there is no need for replacement ballots. Thank you. And Madam Chair, if I may say something, your secretaries were so very kind. When I walked in, they offered me a very comfortable chair, but I had to decline because I didn't want everybody else to feel bad because I had a comfortable chair and they didn't.
Thank you very much. Please begin when you're ready.
Susan Rue, spelled R-U-C-H for the record, and I'm not going to reiterate everything that Lynn just stated, but I am going to go on with the fact that we are not moving towards voter ID. And that the legislation that we keep hearing changes things, but we need to think about how we're going to get to voter ID. And I'm really interested to know if all of you realize that we are the only developed country that is now using mail-in ballots. Brazil, Mexico, we don't look upon them favorably, and they do not use mail-in ballots because it's too much fraud, including Russia. We need to move away from mail-in ballots, and looking at Section 1.5, what they were just discussing, looks like it definitely could lead to lots of voter fraud. In 2021, the legislative session, we heard the voter registrar. He sent out 82,000 uncured ballots, and who knows where they went. So anybody could be signing those ballots, and we need to oppose this bill. And just as a visual, 95% of your voters do not want this bill passed. And I don't know whether you look at this, but it's on your website. Thank you very much for your time.
Thank you for your testimony. Please go ahead when you're ready.
Hi, Madam Chairman and Committee. Barbara Jones for the record. I agree with what the previous has said and will add the following. I am in opposition to the bill too, SB 60, because this statement 2, requiring the Secretary of State to adopt by regulation a cyber incident response plan for elections. And then there's in the next part, on the first page there, it's uniform service voter. Don't like the word uniform because we're trying to get everything uniformed nationally and internationally. Relating to automatic voter registration, DMV, automatic voter. I've never ever been for that. On page 31, it says a voter must complete an application to register to vote by computer using the system established by the Secretary of State. It's taking away, and on the next page it says each county and city clerk and other local election officials are required to comply with the requirements of the cyber incident response plan. So what it is first of all there, you have to vote by machine, which just register to vote by machine for some people. And some people don't have that ability. It disenfranchised some voters. Also, the compliance by the cities and counties, I'm totally against requiring them to comply with the Secretary of State and the National. Thank you, ma'am. Saw your sign.
Thank you very much. If you have additional written testimony, you can turn that into our secretary and they'll put it in the record.
I didn't quite hear you, I'm sorry.
Oh, sorry. I was saying that if you had additional written testimony, you can give that to the secretary and she'll put it in the record. So thank you very much. Okay, is there anyone else in Carson City who would like to testify in opposition? Okay, seeing none, we'll go to Las Vegas. Is there anybody who would like to come to the table, testify in opposition? Okay, seeing no one come up there. Broadcasting, do we have anyone on the telephone?
To testify in opposition to Senate Bill 60, please press *9 now to take your place in the queue.
I'm in Las Vegas in opposition.
Wait, let us quick grab the telephones first, and then we'll come back to you. Thank you.
Okay. Hi, my name is Leslie Quinn, L-E-S-L-I-E. Last name is Quinn, Q-U-I-N-N. I oppose SB 60. This bill adds layers and layers of voter suppression. It will suppress Nevadans' the right to vote. Machines and mail-in ballots cost Nevadans tens of thousands of dollars. Let's make voting easy, save taxpayers thousands of dollars, and bring back trust in the vote. Let's vote on one day, in person, and only allow those in the military who are out of the country, ADA, or elderly that struggle to get to the polls on Election Day to have mail-in ballots. Vote no on SB 60. Save the trees.
Thank you very much. Is there anyone else in Las Vegas who would like to testify in opposition? Okay, saying none, we'll go to broadcasting, and anyone on the telephone to testify in opposition?
To testify in opposition to Senate Bill 60, please press star 9 now to take your place in the queue.
Hello, this is Iris Stone. Can you hear me?
Yes, we can hear you. Please go ahead.
Okay, thank you very much. Good afternoon, Chairwoman and committee people. My name is Iris Stone, I-R-I-S-S-T-O-N-E. I live in Las Vegas. I have 3 sections I want to talk about, and I specifically oppose Senate Bill 60 for that reason. First of all, Section 1A, subsection 2B, adds a new independent party candidate category who can run for office in a general election only. It is unclear to me why we need a new independent party and why it's being created. Having this new party dilutes the list of candidates in the general election, since we can have an unlimited amount of independent party candidates, but only one Democrat, one Republican, one nonpartisan, etc. The creation of this party is totally unnecessary, as it does not serve any purpose except for adding numerous unvetted candidates to the general election lineup. This will confuse and discourage voters when looking at long lists of candidates that they need to choose from. At least when a candidate belongs to a party with a platform, the voter generally knows what the candidate stands for. Based on this section, I oppose SB 60. Another subsection that I would like to cover is number 4, subsection 5B, which outlines provisions in regard to primary elections. The way I interpret subsection 5B, a voter can pick more than one candidate in a primary election, and that vote will be counted for each candidate. Beyond that, the author does not state any further specifics as to how the winner will then be determined. While not specifically called out in the wording, this seems to be a premature setup for ranked choice voting method of determining winners. And as we all know, this has not been approved by the Nevada electorate. For that reason, I oppose this particular section and SB 60. Last, Section 19 repeals several statutes to refer to the accounting for all paper ballots before counting of votes begins. And the other one is a recount of ballots at the hearing of contest. I believe that repealing these provisions would remove the physical inspection of mail ballots for purposes of audits and recounts. Paper trail and chain of custody preservation is critical to a trustworthy election process, including forensic audits and recounts. Moving everything to computers and electronic mechanical devices takes away the assurances we need to provide a paper trail backup that is critical to running fair and transparent
Ma'am,
elections.
you're past your 2
Having
minutes. Can
worked
you
as a
wrap up,
poll-
please?
Yes, I'm just about doing that. Having worked as a poll worker in the ballot processing center where I counted and adjudicated many, many mail ballots, it's hard for me to comprehend that these amendments adhere to existing federal statutes. Thank you very much. I oppose SB 60.
Thank you very much. Broadcasting, do we have any other callers?
Chair, there are no other callers to testify in opposition at this time.
Okay, thank you very much. With that, we will close testimony in opposition. We'll open up testimony in neutral. I see one person in Carson City, so please begin when you're ready.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Cadence Matievich, Cadencematijevich, representing Washoe County. I think this committee is used to seeing our registrar of voters, Ms. Rodriguez, but she was unable to be here this evening. We are neutral on the policy of the bill, but did want to let the committee know that we've worked with the Secretary of State to be sure that if it's the policy decision of this body to pass this bill, that our operational and logistical questions and concerns have been addressed. Thank you.
Thank you very much. Okay, is there anybody else in Carson City who would like to come to the table and testify in neutral? Okay, seeing none, is there anyone in Las Vegas who would like to come to the table to testify in neutral? Okay, seeing none. Broadcasting, do we have anyone on the telephone?
Chair, there are no callers to testify in neutral at this time.
Thank you very much. With that, we will close testimony in neutral and ask the bill sponsor if he'd like to come up to the table for some final remarks. Maybe? Yes? Thank you.
Thank you, Chair Mark Velasquez, for the record. Title 24, the 9 chapters, again, are very detailed, very nuanced, and those of us that are privileged to be able to spend our days working in them recognize that there is certainly some room to adjust them to really address the needs of the electorate and to reflect in a more uniform way across those provisions the decisions of this body. Appreciate your support for SB 60. Thank you.
Thank you very much. And with that, we will close the hearing on SB 60, and we will open the hearing on SB 133. SB 133 revises provisions related to presidential electors. We will ask our esteemed colleague, Senator Daley, to begin when he is ready.
Thank you, Madam Chair, members of the committee. My name is Skip Daly, representing Senate District 13, here to present Senate Bill 133. So I'll go over Section 1 and each of the subsections quickly without, I'm happy to answer questions at the end, of course. So the first subsection 1 of Section 1, basically spells out what a person shall not do, which is the point of the bill. So you can't create a false slate of electors, serve in a false slate of presidential electors, or conspire to create. Subsection 2 establishes the penalty if you are convicted of such an offense, and it has 2 parts. It's a B felony, 4 to 10 years, or you can pay a fine and you would have to repay costs to the Secretary of State or Attorney General as applicable for investigation. Subsection 3 makes it so that the penalty is non-probationable. Subsection 4 lays out if somebody thinks somebody violated one of these provisions, a process for filing a complaint with the Secretary of State and the information, if you have it, that you would want to file with that. Subsection 5 spells out the actions that the Secretary of State may take if they receive such a complaint. They can also act on their own initiative. And if it appears that the provisions are there, they can conduct an investigation, or they can refer it over to the Attorney General's office to conduct an investigation and then proceed with proceedings if there's information. Subsection 6 allows the Secretary of State to issue a subpoena if during the course of their investigation. Subsection 7 also creates so that a person who's convicted of this can't then subsequently run for office or be appointed to position in state government. And then subsection 8 in A, B, and C gives a little more definition, so we just are not in a nebulous deal on what the acts are that you would have to do in order to be convicted. So it spells out what conspire to create means, what to create a false slate means, and to serve in a false slate. So in coming up with the provisions and the revisions we made from the original draft, I worked with the Secretary of State's office. They had some suggestions, worked with the Attorney General's office, and they had to part there on the definitions to try to make sure that if we did have this situation that either one of those officers could effectively prosecute if they needed to do, and that they had the tools, and that it wasn't an abstract concept. So that's why we had the definitions that we put in there. And I believe one of the reasons that this particular bill is needed is because there's not really a law at this point on point to address this particular issue. In theory, if somebody did this, they could be accused or potentially prosecuted for putting in a false document or for fraud, but nothing specific on point. And it would be, I think, difficult at this point to carry out if somebody did do that. Sections 2 and 3 make conforming changes in regard to a person who can't run for office or be appointed. And then Section 4 says when it becomes effective, which is upon passage and approval. Wanted to be quick. I know you've got a game to go to, but I'm on Team Senate, sorry. Not playing, but to go Team Senate. So with that, I'm happy to answer any questions, Madam Chair.
Thank you very much. Go Team Assembly. Committee, any questions? Okay, we have Assemblyman Hibbets, please.
Thank you, Madam Chair, and thank you, Senator, for coming all the way up to the third floor today. I'm going to ask you about Section 2 and 3, where it says that in Section 2, 4 years after the date of discharge from parole, and then Section 3 has same language for release from prison, where it says that restored, where did it go? Discharge from parole is restored to the right to hold office unless the person was convicted pursuant to Section 1 of this Act. So if you were convicted of filing a false slate of electors, then you can never hold office again. Am I reading this correctly?
Thank you, Madam Chair. To the Assemblyman, Skip Daly again for the record, representing Senate District 13. You're reading it correct, except it would be limited to the state of Nevada.
Okay, so somebody that, let's say, stabbed somebody else would be able to be elected or appointed to elected office, but not someone that committed a paper crime, essentially.
Thank you, Madam Chair. Again, Skip Daly for the record. I wouldn't characterize this as a paper crime. Nevertheless, everybody has their opinion on that. If you did get convicted of stabbing somebody, it depends on what you were actually convicted for. Along with that, you would have to be out of jail in order to run, and then depending on what felony it was, you would have to be out for, I believe it's at least 7 years, depending. It could be a shorter period of time. But if you're out, you would still get to vote.
Okay, go ahead.
I'm sorry, quick clarification. When I say paper crime, I meant non-violent. That was my distinction. I apologize if that was unclear.
Thank you. I have a comment from Vice Chair Miller.
Thank you, Chair Gorlow. I just, based on what you were saying, Senator, I think what I appreciate, and I know it seems confusing to some because with all of our sentencing guidelines in this country, sometimes it doesn't seem equitable, or how come violent offenses versus nonviolent offenses, but I really consider that what you've done here is actually, to commit this crime, it is actually an offense against our republic and our democracy in itself. And so, to me, I believe that we need to preserve this, and so I appreciate your bill. Thank you.
Thank you. Next, we have a question from Assemblyman DeLong.
Thank you, Chair. Section 3 of the 14th Amendment of the Constitution bars certain individuals from holding federal office for the armed insurrection that we call the Civil War. In this bill, we're equating it, those activities, to an armed insurrection of this country. That seems to be extreme from my perspective.
Thank you, Madam Chair. Again, Skip Daly for the record. I guess I'll address or both comments, so thank you to the Assemblywoman, and I understand everybody has their perspective on what it is. I do believe for these particular acts, we should try to make sure we're defending the process, the integrity of elections, and our country and the way we elect a president. So that's why I'm happy with the way the bill is.
Thank you very much, Senator. We'll go to Assemblywoman Gonzalez, please.
Thank you so much for the presentation. I just had a few questions. Number one, I was curious if there was a statute of limitations on this.
Not that I'm aware of. I wouldn't, I don't know. We haven't put one in the bill, obviously. But it seems to me if this was going to happen, there would be an inherent limit. If someone's going to file a complaint, they would have to, I'm assuming it's going to happen within the 4 years after the election. But other than that, no, I don't believe there's a statute of limitations. I believe the prosecutions, if there was going to be one, and the complaint and investigation and would happen swiftly. I mean, I personally believe and hope this is never used and that there won't be a need to use it. However, if there is, I believe that we wouldn't have to worry about any statute of limitations.
Thank you. And then my other question is in section, what is it? Section 1, number 4, it describes like what a person has to include if they believe that this violation has taken place. If they don't have all this information, will that complaint still be investigated, or is it putting it in statute saying we have to have all of these and then we will investigate?
Thank you again. Sorry, I don't think I said Skip Daly for the record last time. My apologies. No, this was meant to be a guideline on the type of information that we would hope to see, that we, we're trying to avoid a frivolous complaint. Hey, so-and-so just did this. If they just said that and there was no backup, no evidence, no timeframes, basically nothing to support it, it probably wouldn't get an investigation if there was nothing to back it up. So we're trying to give a guideline on some of the things that do that. We're trying to avoid people just putting in a frivolous complaint.
Thank you. And then my last question, and thank you so much, Chair, for the indulgence. And I don't know if you would know the answer to this or not. We know that many crimes are pleaded down. And so in this event, if somebody was charged with this, what would that look like if that would be something that would happen? And just curious what you envision for that. Thank you.
Again, Skip Daly for the record. So no, I'm not certain if it could be pleaded down. In the penalty, it's a B felony, 4 to 10. So I think there's discretion on the part of the judge to have it be less than 10, but it's got to be at least 4. And then it's non-probationable on that. So I don't think that there's much wiggle room.
Thank you. Committee. Oh, we've got a question by Assemblywoman Dickman.
Thank you, Chair. I'm just curious, how many times, does anyone know how many times this has happened ever, besides maybe once?
Thank you, Madam Chair. Again, to the Assemblywoman, Skip Daly for the record. I believe it only has happened in Nevada the one time, and this bill, I'm hoping, will make sure it doesn't happen again.
Okay, thank you. Thanks, Chair.
Thank you. Committee members, any other questions? Okay, seeing none, thank you very much. We will open up testimony and support for SB 133. Please begin whenever someone is ready. Thank you.
Good afternoon, Chair, members of the committee. Cisco Aguilar, Secretary of State, here to testify in favor of the bill. I appreciate the Senator's effort and willingness to bring this forward and his work on the bill, so thank you.
For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We are here today in support of SB 133. We saw during the 2020 election the problem of mis- and disinformation and how that played in those elections. We do work in this field every day. We saw the embarrassing role that Nevada played in all of that. January 6th and all of the events leading up to January 6th should never happen again, and we must do better. This bill is an important step to protect our democracy. We urge you to pass it. Thank you.
Thank you. Please begin when ready.
My name is Sarah Mahler, 26-year resident of Sparks, Nevada. I am testifying in support of Senate Bill 133 because any person conspiring to create a false slate of electors threatens the future of our democracy and our country. In my personal experience as a duly elected presidential elector in the 2022 elections, I understand the importance of the integrity of the process, which fake electors attempted to undermine. Anyone who conspires to subvert the electoral process is a threat to our democracy and a danger to our society. The consequences must be clear that this behavior cannot be tolerated, and I urge you to vote in support of Senate Bill 133. Thank you.
Thank you. Is there anyone else that would like to come to the table in support of SB 133? Okay, seeing none, we will go to Las Vegas. Please press the button and begin when ready.
Good afternoon, Chair Gorlow and members of the committee. My name is Aaron Ford, and I'm your Attorney General. I'm here to testify in support of Senate Bill 133 this afternoon because this proposed legislation will give our state the tools it needs to protect the security and the integrity of our elections. I'd like to thank Senator Daley for bringing this bill forward. In the 2020 election, we saw a concerted effort to undermine the results of our election and democratic processes. This manufactured propagandistic lie that there's some sort of mass voter fraud conspiracy has damaged trust in our democratic process. In the aftermath of the 2020 election in battleground states, including Nevada, Republican electors submitted fake electoral certificates declaring former President Donald Trump the winner of the 2020 presidential election. This was a lie. Trump did not win this election, and the fake electoral certificates were simply another propagandistic tool used to further this lie. As you know, I have been silent on Nevada's fake electors, except to say that the matter was on our radar. With it on our radar, we ascertained that current state statutes did not directly address the conduct in question, to the dismay of some and I'm sure to the delight of others. But I also acknowledge that we would continue to work with the Department of Justice in its investigation into this matter. We maintain that willingness to assist the DOJ. We saw and continue to see a contingent of folks willing to undermine our elections and democratic processes. We saw it with the harassment of poll workers. We saw it with these fake electors in Nevada and in other states. And we saw it in terms of the insurrection in our nation's capital on January 6th. With this bill, Nevada law would make it clear that those involved in schemes such as those undertaken by Nevada's fake electors can be held accountable. It spells out neatly in Section 1, subsection 8, what it means to create, conspire, or create, and to serve as a fake slate of electors and to present such a slate. It would allow our office or the Secretary of State's office, as appropriate, to claim the costs of investigation and prosecution of those involved from those convicted, as decided by a court. As long as I'm Attorney General, I will never stop fighting against those seeking to undermine our elections. I will never stop fighting against those who seek to undermine our democracy. And this bill gives my office the tools it needs to do just that. I urge your support. Thank you so much, Madam Chair.
Thank you very much, Attorney General, for being with us today. Is there anyone else that would like to testify in support in Las Vegas? Okay, seeing none, broadcasting, we'll go to the telephone. Is there anyone on the phone lines?
To testify in support of Senate Bill 133, please press *9 now to take your place in the queue. Chair, there are no callers choosing to testify in support at this time.
Thank you very much. With that, we will close testimony in support of SB 133 and open up testimony in opposition. We'll start in Carson City. Please come to the table. You may begin when ready.
Good morning, good evening, Madam Chair. John Pierre from the Clark County Public Defender's Office. I just want to say I take any attack on our democracy and our Constitution very seriously. My issue right here is with the punishment directly. That is Category B felony punished by 4 to 10 years in prison. No chance for a judge to even consider probation. So a person who doesn't have so much as a traffic ticket, doesn't have so much as a minimal misdemeanor, the judge is going to have to sentence that person to 4 to 10 years in prison without even taking into account their mental instability, their cognitive impairment, any disability they may have, anything of that nature. And that's part of the problem that I have. Just to put that 4 to 10 in perspective, let's talk about that real quick. Senator Daley could be real mad at me for testifying on this bill, punch me in the jaw when I leave this stand, break my jaw, and he will get less time than what this bill is asking for. Assemblywoman Newby can threaten Assemblyman MacArthur with a knife, get less time than what this bill is asking for. The QAnon shaman that wore that stupid hat and stormed the Capitol, that guy got less time than what this bill is asking for. So that's my problem with the non-probationable nature of this offense and mandating that it be 4 to 10 years. I think it's appropriate for us to punish something like this, but I think our punishment needs to be measured. It needs to take into account a particular person's situation, what's going on, how they got wrapped up in this whole thing, and let the judge have discretion. If Senator Daley was to amend this bill, we would withdraw our opposition. I have tremendous respect for Senator Daley, and I just wish he would remove that section of the bill and leave it up to a judge to handle everything on a case-by-case basis. Thank you.
Thank you. Please go ahead when ready.
Thank you. Good evening, Chair and members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. I echo the sentiments of my colleague from the South. I think that when we're talking about this body is tasked with proportionality when we're talking about setting new crimes. And it is a very important task that is undertaken, and we can't do it lightly. And so the only thing I will add is it's not just if somebody is punched in the jaw or threatened with a knife. If we're talking about January 6th, the individual who actually assaulted police officers, violently assaulted police officers, this is the kind of time they're looking at. And so this is not a violent act. The policy purpose is important, but it is a bigger issue when we're sitting down and creating new crimes that the penalties for those crimes are proportional to the action. And so, as my colleague from the South said, we agree with the policy intent, but the penalty and specifically the non-probational portion we oppose. Thank you.
Thank you very much for your testimony. Please go ahead, Ms. Chapman.
Madam Chair and Committee, I'm Lynn Chapman, and I'm the State Treasurer of the Independent American Party. Excuse me. The proposed bill appears to be a political reaction to the events of 2020 that were not important enough to address in the 2021 legislature. However, should a future presidential election have issues requiring litigation, Congress included the Electoral Count Reform and Presidential Transition Improvement Act of 2022, the ECRA, in the passage of H.R. 2617, the Consolidated Appropriations Act of 2023, which was signed into law by President Biden in January 2023. The ECRA clarifies that the Vice President's role in the proceedings is purely ceremonial. The measure also raises the bar for objecting to a state slate of electors. Prior to passage, it required just one member of the House and one senator to challenge a state's electors, a provision that had been invoked by members of both parties in multiple presidential elections. The ECRA raised the threshold for an objection to 20% of the members of each chamber. The ECRA reforms sufficiently address the issues by encouraging litigations to be completed by the safe harbor day the electors must vote, but not by mandating that acknowledges that the judiciary process must be allowed to run its course without making those seeking judicial relief excuse me, allergies, judicial relief into criminals as proposed by SB 113. Additionally, the bill has multiple provisions which make it unconstitutional. For example, references the Uniform Faithful Presidential Electors Act in Nevada law, which may be unconstitutional because it injects several steps by the state of Nevada in the process of electors voting, which violates SUSC and the 12th Amendment to the Constitution, which 3 USC specifically references. Electors are performing a federal function because electors' capacity to perform results from no power, which was originally resident in the states, but instead springs directly from the Constitution of the United States. Therefore, Article 6, Clause 2 of the Constitution, the Supremacy Clause, governs their function.
Ms. Chapman, you are at 2 minutes.
Oh, okay. Well, that's close enough. I only had one more sentence.
Finish your one sentence.
Okay. The bill seeks to unconstitutionally limit electors from exercising their legal rights and is unnecessarily due to the reforms passed last month in the ECRA. Please vote no. Thank you.
Thank you very much. Is there anyone else in Carson City who'd like to come and testify in opposition? Okay, please go ahead and begin when you are ready. Is your microphone on? Sometimes that button doesn't work
I
very well.
pushed it not hard enough.
I know. Sometimes you got to push it
Sorry.
2 or 3 times. Please start over.
Okay. Yes, I'm in opposition to SB 133. I agree with what has been said. One of the concerns I have is that there's no protection in here for people that have been alleged by a written statement to the Secretary of State. And I don't see where they get a trial or how the prosecution and adjudication of it occurs. On page 3, it just says that the Secretary of State shall conduct an investigation. I was told by a Secretary of State, not this one, that they don't do investigations. I guess they have to check into something, but I was told we have to do the investigation and present the proof. So the alleged violation and all that the punishment is just not right or fair or even legal, I believe. It says either that and they can refer it to the Attorney General or cause the appropriate proceedings to be instituted and prosecuted, but it really is not clear at all. A person who believes that the provisions have been violated may notify the Secretary of State. An example, and I have to bring up, giving it to the Attorney General, just because, and I'm speaking of any Attorney General, but just because they don't look at the evidence doesn't mean things are lies. It doesn't mean things are lies if the evidence hasn't been looked at. A person convicted, false statement. I have to mention also, the best example came to my mind when Attorney General Ford was speaking and relates totally to what I said, wrote here before I heard him. Where's the protection for a victim that might be falsely accused? They have to have a day of trial. And one of the January 6th people wasn't even at the January 6th and got arrested for thinking about going. So somebody made an allocation against him. And what, 600-700 people in there for a couple of years without a trial? That's not right. So this, I have to be against the investigative powers
Ma'am, you're
and
over your 2
increased
minutes.
SOS involvement. Thank you.
Thank you. Is there anyone else in Carson City who would like to testify in opposition? Okay, seeing none, we will go to Las Vegas. You may begin when ready.
Yes, my name is Leslie Quinn, L-E-S-L-I-E, last name Quinn, Q-U-I-N-N, and I oppose SB 133. None of us want violence in our constitutional republic. Look what's going on at the Texas border with Title 42 ending today. SB 131 is a game plan to have it your way in 4 steps. Identify what you call the problem, prioritize based on consequences, define the ideal scenario or outcome, and develop a solution or a proposal. SB 133 is another legislative attempt to block Nevadans' freedom to vote how they want. This bill sets up a roadblock for Nevadans to vote for number 45 if they want, or if they choose to. This is their choice. This is our choice as Nevadans to vote for whoever we choose based on how we want to vote. This is not SB 133's roadblock choice. This is more evidence of government overreach. Don't we all want to make America great again, no matter who is the POTUS? Please vote no against SB 133, and I also ask my legislators, Brittany Miller, Assemblywoman Brittany Miller, and my Senator Marilyn Dondero Loop to please vote against SB 133 and allow us as Americans to live in a constitutional republic where we can choose to have whoever we want to vote for. Thank you.
Thank you. Is there anyone else in Las Vegas who would like to testify in opposition of SB 133? Okay, seeing none. Broadcasting, do we have anyone on the telephone?
To testify in opposition to Senate Bill 133, please press star 9 now to take your place in the queue. Chair, there are no callers to testify in opposition at this time.
Thank you very much. We will close testimony in opposition, open up testimony in neutral. Is there anyone in Carson City who would like to come to the table to testify in neutral? Okay, seeing none, we'll go to Las Vegas. Is there anyone in Las Vegas who would like to testify in neutral? Okay, seeing none. Broadcasting, do we have anyone on the telephone?
To testify in neutral for Senate Bill 133, please press star 9 now to take your place in the queue. Chair, there are no callers to testify in neutral at this time.
Thank you very much, Broadcasting. With that, we will close the testimony in neutral and invite our sponsor, our bill sponsor, to come up for some final remarks.
Thank you, Madam Chair, members of the committee. Again, Skip Daly, representing Senate District 13 for the record. And a couple of comments. This bill doesn't inhibit in any way anybody's right to vote. You can vote for who you choose to. As you know, each state doesn't actually vote for the president. They vote for a slate of electors. Technicality, most people don't understand. Second thing, as far as the constitutional provision and the law that Congress passed regarding electors, this bill does not affect or change anything and would not be in conflict with that for the actual electors from the state of Nevada. Anyone that are not actual electors, it would affect them. And then as far as the penalty goes, I believe that we have a measured penalty. There should be consequences for the acts that we're talking about in protecting the way we elect president and making sure that we uphold the democratic principles is important, and I think the penalty is measured.
Okay, thank you very much. With that, we will close the hearing on SB 133, and we will open the hearing on SB 406. Senate Bill 406 revises provisions relating to elections. Thank you both for being here again. You can start when ready. And before because I haven't said it yet, just go directly to the members. All right, there.
Well, good evening. Cisco Aguilera, Secretary of State for the record. With me, I have Deputy Secretary for Elections, Mark Velashin, and Chief Deputy Gabriel DeCara in Las Vegas. Thank you to Chair Gorlow and members of the committee for hearing our presentation today. Last night, our office received extremely disappointing news. A federal jury found a man charged with threatening election workers in Nevada not guilty. In 2021, the day after the Capitol insurrection, this man called our office and gave death threats to our employees, threatened their children, and harassed them repeatedly. This is unacceptable. The employees in the Secretary of State's office deserve justice for what they endured, but they didn't receive it. Election workers must know the law will protect them from the dangerous individuals who want to make them afraid. Unfortunately, the spread of irresponsible, false rhetoric about our elections that spurs this violent behavior is not stopping. The employees in the Secretary of State's office are not alone. What they've had to endure for just doing their job. We must take action now. One of these issues in the case was the lack of clarity in existing law around these threats. That's why I brought this bill and why I'm asking for your support. Senate Bill 406 increases protection for election workers and makes sure that the people know that there are real consequences for trying to interfere with the democratic process. I'm grateful for the members of the Senate floor, who unanimously passed Senate Bill 406, showing strong, united front to stand up for election workers and protect them against the threats and intimidation. Our election workers and volunteers are key to a functioning democracy. As we discuss legislation here in Carson City, it's critical we are ensuring that we meet the needs of our counties, including the need for security. I've met with several county and city election departments across Nevada in my first 4 months as secretary, including Story County early today. To hear about these needs, or those needs in their own words, is critical. Since 2020, only 7 of the 17 county election officials stayed in office. Many others have left. And you can tell why just by what happened in my election divisions. Counties are having a hard time recruiting new workers because people simply do not want to go to a workplace in fear. Elections don't work without people. Threats against election workers are threats against democracy and have no place in Nevada. Protecting election workers so they can continue to run fair and transparent elections in our state is absolutely critical. The future of our democracy and our freedom to vote depend on it. Now I will hand over the presentation to our Deputy Secretary for Elections, Mark Velashan, to discuss provisions of the bill. Thank you.
Good evening, Chair Gorlow and members of the committee. I'm Mark Velashan, Deputy Secretary of State for Elections. There are essentially 3 main elements to Senate Bill 406. First, there are provisions that protect election officials. The bill proposes to make it a crime punishable as a Category E felony for any person to use or threaten or attempt to use any force, intimidation, coercion, violence, restraint, or undue influence with the intent to interfere with the performance of the duties of any election official relating to an election or retaliate against any election official for performing duties relating to an election. Of note, those provisions apply regardless of whether these actions are conducted at a polling place or not. If an election worker is followed home, for example, the statute would still apply. The second element of the bill addresses the unauthorized release of an election official's personal or sensitive information. The bill proposes to make it a crime for any person to disseminate any personal identifying information or sensitive information, which are both already defined in statute, of any election official without the consent of the elections official and with intent, as in Section 1 of the bill. Finally, the third element clarifies that certain activities which are already established in statute are not restricted. These include, for example, observing the conduct of voting at a polling place and observing the counting of ballots at the central counting place. That concludes our presentation. We are available for questions.
Thank you very much for your presentation. Committee members, do we have a Speaker Yeager? Please go ahead.
Thank you, Madam Chair, and thank you for the presentation. I just had a quick comment and then a question. Election workers are critically important, and I know how hard it's been, especially when we had COVID hit, and folks generally just didn't want to be out there with folks. And as you said, we can't make this process work without volunteers, and everybody deserves to feel safe. So appreciate you bringing this forward. I did happen to read that story from yesterday, and without knowing all the facts, I don't know why the jury ruled how they did, but those threats seemed pretty serious to me, so I think anything we can do to make that clear in the law is warranted. So that's the comment, and then the question is just this. Obviously, this is a change in the law in the sense that we're clarifying exactly what you can and cannot do. So I just wondered if you had thought as an office about how this would be communicated. I mean, obviously, people just have to be decent people to one another, but we know that elections can get folks very fired up at times, and so I wondered if you had thought about things like at actual polling places, having signage up indicating that, maybe you already do that, or maybe in the sample ballots that are sent to people so that we can remind folks, maybe in a moment of rationality, that they can think about, this isn't about being angry or upset that your candidate won or didn't win, but this is about the human element of people who volunteer their times to make this process work in our country. So if you could speak a little bit to that, maybe already do it, or if not, if you've got some plans to be able to get the word out to folks.
Thank you, Speaker Yeager. Yes, that is definitely a conversation. We do speak with the county clerks every other week, and this would be on our agenda to discuss if this bill were passed. Our fingers are crossed that the bill will pass because we are collectively asking for this. This is not a Democratic or Republican issue. This is about an issue of making sure Nevadans have an opportunity to express their fundamental right to vote. And if we don't have the human component to work these polls, we're not going to see that process work well. We need to stand up and say, we do not appreciate this. The fact, we couldn't have the issue with the case in the federal court and having the verdict come down yesterday. It was so timely for this hearing because I can tell you it has put a chilling effect in our office as of today because people are afraid. They are suffering. They're struggling just knowing that something like this can continue to happen, and that's why this law is so needed. Thank you.
Thank you very much. Committee members, other questions? Okay, Assemblyman Hibbets.
Thank you, Madam Chair, and thank both of you for the presentation. Just for clarification's purpose, can you repeat what category of felony this crime is, and would you mind using a phonetic also, just so that it's clear for the record for anybody listening?
Thank you for the question, Assemblyman. Mark Volashin for the record. This will be a category Echo or E felony.
Thank you very much. Thank you, Chair.
Thank you. Committee members, any other questions, comments? Assemblywoman Dickman.
Thank you, Madam Chair. Can someone just tell me what the penalty is for that level felony?
Thank you for the question, Assemblywoman. Mark Volashin for the record. I'll get you the information. It is defined in statute and perhaps, thank you.
Please go ahead.
Legal.
For the record, this is Heidi Clarkson with the Legislative Counsel Bureau. Under NRS 193.130, a Category E felony can be sentenced a minimum of not less than 1 year and a maximum term of 4 years. The court can also suspend the execution of the sentence and grant probation as well.
Thank you, and thank you, Chair.
You are welcome. Committee, any other questions? Okay. Seeing none, thank you very much. We will open up testimony in support of SB 406. Please go ahead when ready.
Hello, committee members. My name is Jennifer Willett, Willett, and I am the grassroots manager at All Voting is Local Action, an organization that exists to expose and dismantle threats to voter freedom. AVOL Action is also a member of the Let Nevadans Vote Coalition, and we are here in strong support of SB 406. Since 2020, election workers have increasingly become targets for harassment, intimidation, and even physical violence. In Nevada, this has included cases of election officials being followed home, receiving death threats, and worrying about the safety of their children. This alarming trend has contributed to the high turnover of election officials in our state, with 4 election officials explicitly and publicly citing harassment as one of the reasons for leaving their jobs in recent years. As one clerk put it, life has been hell. Furthermore, some former temporary election workers have declined to work recent elections due to their fear. The situation is unacceptable. The state should be doing everything in its power to facilitate the safety and security of our election workers, and SB 406 does just that. It is regrettable that such legislation has become necessary, but it is an essential step towards protecting election workers from harm and safeguarding our democracy. Election workers deserve to be recognized for their vital contributions to our great state and should be able to do their jobs without harassment and threats. AVOL Action urges support for SB 406 to ensure the safety of election workers in Nevada. Thank you.
Thank you. Please go ahead when ready.
Good evening, Chair and members of the committee. For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We are here today in strong support of SB 406. Our election officials are here to ensure that our elections are safe, secure, and accessible for all Nevadans. SB 406 is a bill that will protect these individuals who work day in and day out from those who would wish harm upon them or their loved ones. These threats they receive have become all too common. We need to be providing these officials with adequate support, and we believe this bill is an important step in the right direction. We also thank the Secretary of State's office for working with our groups in the creation of this legislation. We urge this body to support the bill. Thank you.
Thank you very much. Next person, please go ahead.
Ket Irvin, for myself as a voter in Reno and as the spouse of a very long-time poll worker and poll manager. The stories used to be about the challenges of getting a set of volunteers, often senior citizens, up to speed on the tech, getting everything done, getting the results in a timely manner, and doing all of that. But in the last few years, it's been about the difficulties of having enough poll workers and then having colleagues at the county quit the jobs because of these kinds of threats at the election. So this is just so important that we protect our election integrity in this manner. Thank you.
Thank you very much. Please go ahead when ready.
Sarah Mahler, Sparks resident. We saw in Washoe County what happened with our registrar of voters, and nationwide, this isn't just here in Nevada, and election workers are leaving their jobs due to threats, intimidation, and safety issues. Nevada election workers deserve to be protected while serving our electorate and protecting our democracy. I urge you to vote in favor of SB 406 to keep our election workers safe. Thank you.
Thank you very much. Please go ahead.
Chair Gorlo, members of the committee, Isaac Torrio with Strategy 360, today representing Campaign Legal Center, a national nonpartisan nonprofit organization that works to protect and strengthen American democracy across all levels of government. We urge you to support SB 406 to protect election officials in Nevada. Election officials across the country have been on the receiving end of an onslaught of threats, harassment, doxing, and stalking that has escalated to an undeniable crisis here in our state. Nevada, unfortunately, isn't the exception. Despite there being efforts to keep this under fire, it still keeps happening and preventing election officials from performing their duties. 10 out of Nevada's 17 counties have lost their clerk or registrars of voters since 2020, with many of the resignations coming in response to threats and harassment. Currently, many credible threats of violence are escalating and escaping legal consequences. This bill would change that, making it possible to effectively prosecute for these threats and violent behavior while providing a strategy to keep officials safe by allowing them to keep their personal identity information sealed from those who would seek, threaten, or harass them. Dedicated election officials are a necessity for the type of free, fair, and secure elections that Nevadans deserve. We must do more to protect them, and we urge the committee to support SB 106. Thank you so much.
Thank you very much. Please
Good
go ahead,
evening,
Mary.
Chair Garlow, members of the committee. My name is Beth Schmidt. I represent the Las Vegas Metropolitan Police Department. We support SB 406, and we appreciate the Secretary of State Aguilar for bringing this bill forward to protect our election workers in Nevada.
Thank you very much. Is there anyone else who would like to testify in support in Carson City? Okay, seeing none, we will go to Las Vegas. Please go ahead when ready.
Thank you, Chair Gorlo and members of the committee. My name is Eric Jang, ERICJNG, Acting Executive Director of One API Nevada, and also here today as Director of Outreach for Asian Community Development Council. As a core member of Let Nevadans Vote Coalition, as someone that has recruited dozens of nonpartisan election protection observers and volunteer workers, democracy is on the line. Exercising our voting rights should be sacred and free from fear and intimidation. We thank the Secretary of State and his office for bringing forth SB 406, and we also saw how frustrating and how deeply regrettable that the jury's news from yesterday. Department of Justice investigated more than 1,000 contacts across the nation and only brought forth 8 cases, and one of that was our Nevada's that happened. So we definitely need a state legislation that can help protect our election workers, as well as in our work with county registrars and Secretary of State. We really want to thank them for their sacrifices and their service. Thank you.
Thank you very much. Is there anyone else in Las Vegas who would like to testify in support? Okay, seeing none. Broadcasting, do we have anyone on the telephone?
To testify in support of Senate Bill 406, please press star 9 now to take your place in the queue. Caller with the last digits 201, please press star 6 to unmute yourself.
Good evening. For the record, my name is Emily Prasad Zamora, spelled PERSAUD-ZAMORA. I'm the Executive Director of Silver State Voices, which leads the Nevadans Vote Coalition, and today we're here in strong support of SB 406. This bill is near and dear to our hearts because we know that election officials are the unsung heroes of our democracy. They work tirelessly to run Nevada's elections and ensure all voters can cast their ballots. It's unacceptable that our public servants have been subjected to harassment and threats for simply doing their job. We support this bill as it provides legal protections for election workers against intimidation, violence, disseminating personal information without consent, physical injury, and stalking. Part of our work at Silver State Voices is helping recruit election workers during election cycles. Safety is still a priority for election workers, and it's something that we have to consider when recruiting candidates. This bill's passage will go a long way in attracting the qualified candidates we need for our democracy. Lastly, we also appreciate the added language to protect the constitutional rights of observers. Observers should not have to fear for their safety while participating in democracy. We'd like to thank the Secretary of State and his office for including us as stakeholders on such an important topic. This committee can do its part in giving public servants a sense of security by passing SB 406. Thank you so much for your time.
Thank you very much. Broadcasting, next caller, please.
Caller with the last digits 017, you are unmuted and may begin.
Sorry about that. Yes, my name is Davis Hushkon. I am the executive assistant with the Las Vegas Indian Center, and I actually did work the 2022 elections as a poll observer for the elections. And from what I've experienced, it was great watching how everything was orchestrated. The poll workers, the poll monitors, everyone did their job accordingly. And from what I've seen, there was lack of security and there was no type of ordeal that was happening, but we do have to have something in that nature to protect the people that are voting, the observers, and also the election officials that are involved. So we here at the Las Vegas Indian Center are in support of SB 406. Thank you.
Thank you. Broadcasting, next caller, please.
Good afternoon, Chair Gorlow and committee members. I am Teresa Crawford from Henderson, a volunteer member of the Sierra Club's Legislative Committee. And on behalf of the club and our more than 30,000 members and supporters statewide, we speak in support of Senate Bill 406 and thank the Secretary of State and his staff and everyone who worked so hard to bring it forth. The 2020 election cycle saw an unprecedented rise of threats of violence against election officials, from top administrators to the temporary poll workers. Many of them are seniors and election department employees. Fueled by disinformation, these threats extended beyond the workplace to their homes and families, as we've already heard. A former Washoe County registrar stepped down and other workers quit because of the threats and harassment. Armed protesters gathered at the Clark County Election Department nightly while the vote count was underway. A Brennan Center study found that 1 in 3 election workers have serious concerns for their safety. Our election workers are essential to the peaceful transfer of power from the presidency to local races, and we can't thank them enough. However, we can, as citizens and lawmakers, give these devoted officials the assurance of safety for them and their families in the next election cycle by enacting this bill. The specific language prohibits intimidation, stalking, and doxing, and every form of harassment against all election workers and employees of the Secretary of State's office and everyone with duties related to elections. For these reasons, we urge you to support this bill. Thank you.
Thank you very much. Broadcasting next caller, please.
Good afternoon, Chair and members of the committee. For the record, my name is Danielle Fitzgerald. That's DANIELLEFITZGERALD, and I'm the Deputy Organizing Director with the Progressive Leadership Alliance in Nevada, here in support of SB 406. At PLAN, we believe that our democracy is most vibrant the more people that are participating in it, and that includes our election workers who work tirelessly to ensure that our elections are conducted in a safe and secure way and that every vote is counted. No one should be threatened or harassed for doing such important work for our nation and state. We also want to thank the Secretary of State's office for working with stakeholders to ensure that our coalition's nonpartisan election outreach efforts can be maintained. Our volunteers work to ensure that every voter has a positive experience and has their needs met at a polling location while waiting in line, often before they even interact with election staff. This past election cycle that included passing out hand warmers in Washoe County as it snowed, ponchos in Clark County while it rained, alongside snacks and bottled water. SB 406 will protect our election workers and in turn our democracy. We urge your support.
Thank you very much. Broadcasting next caller, please.
Good evening, Chair and members of the committee. My name is Brianna Escamilla, BRIANA ESCAMILLA for the record, and I'm calling in on behalf of Planned Parenthood of the Rocky Mountains, which is a member of the Let Nevadans Vote Coalition. And we are in strong support of SB 406 because free and fair elections cannot take place without dedicated election officials, and it is vital that we are protecting these civil servants from harassment, intimidation, and violence. We're grateful to the Secretary of State's office for bringing this bill forward, and we urge your support. Thank you.
Thank you. Broadcasting next caller, please.
Good evening, Chairwoman and members of the committee. For the record, my name is Donna West, and I live in Assembly District 14. I am here in support of SB 406. During the 2020 election cycle, I was a vote count observer at the Clark County Election Office and saw the increase in intimidation and violence there. We started with protesters pounding on the windows screaming, "Stop the count," while everyone was trying so hard inside to get their work done. One young man who worked for the election department was followed from the office to his nearby bus stop and accosted there. No one should have to suffer this in order to carry out our democratic responsibilities in carrying out free and fair elections. I thank the Secretary of State for bringing forward SB 406, and I urge your support. Thank you.
Thank you very much. Broadcasting next caller, please.
If you have recently joined and would like to testify in support of Senate Bill 406, please press *9 now to take your place in the queue. Caller with the last digits 066, please press *6 to unmute your phone. You are unmuted and may begin.
Good afternoon, Chair, members of the committee. For the record, my name is Guillermo Barahona, Guillermo Barahona, and I'm speaking on behalf of Chispa, Nevada in support of SB 406. Over the last few years, our great state has taken steps to have a more accessible and secure elections for our citizens. Despite our progress, our election officials and frontline workers have become increasingly harassed with their work. This is not limited to government workers, but to the many volunteers and community members that take the time to ensure that our elections run smoothly. Our work at Chispa is community-centered, and we have had members of our community volunteer during the election, witness and endure this harassment. We believe this bill ensures steps to protect our election workers who labor day and night to ensure accurate counts and make Nevada one of the most successful states during election season. Please support SB 406. Thank you.
Thank you. Broadcasting, next caller, please.
Chair, there are no callers to testify in support at this time.
Thank you very much. We will close testimony in support and open up testimony in opposition, starting here in Carson City. Is there anyone who would like to testify in opposition here in Carson City? Okay, seeing none. Oh, we've got one. Come on up. And if someone could also help her with the microphone button just to make sure that it lights up, because sometimes it's tricky. Thank you.
Barbara Jones, for the record. This kind of hits home with me. As I was reading the bill, I was getting kind of a headache about all of the people. It's not just election workers. It's not just the Secretary of State in the bill. I mean, it's social workers. It's pretty much anybody connected in any way with the government. But there's a lot of people out there too that get threats. I have that are not connected with the government. Can I hide all of my information? Is it okay to go to DMV and change my personal information? It's sad we reached this point that elected officials and anybody, can have trouble. It's just sad. But this isn't the protection. It's protecting some of the public from maybe reaching you that they need to. It depends on what information you want to hide. So I can't support it. I understand some people live in fear, but I hope you can get over the fear. It doesn't happen to everybody. It's happened to people in Congress, to presidents, to the public in general. This doesn't give the public in general any way to do the same thing, protect our information. Thank you again. Have a good day.
Thank you very much for your testimony. Is there anyone else in Carson City who would like to come up to testify in opposition? Okay, seeing none, we will go to Las Vegas. You may begin when ready.
Good afternoon. My name is Leslie Quinn, and I oppose SB 406. I often hear the repetitive blaming of the 2020 elections to substantiate pretty much everything going on in the United States. People, let's be grown-ups, build a bridge and get over it. We can't grow forward if we keep looking in the rearview mirror. SB 406 is filled with redundancy. Doxing is already illegal in Nevada. State and federal election laws are currently in place to protect election staff and voters from violence, threats, restraints, use of force, intimidation, coercion, and undue influence with the performance of duties. SB 406 promotes fear in Nevadan voters. It's an insult to every Nevadan who has endured abuse of the ruling party, illegal behavior in or out of the polls. SB 406 threatens every Nevadan's fundamental First Amendment right to freedom of speech. It is a form of voter suppression that endangers citizens' rights to vote free of intimidation. It creates legislation for supposed problems where minimal evidence, if any, exists. We, the Nevadan people, live in America, not communistic China or Nazi Germany. Where's our courage? Please vote no on SB 406. It breeds fear and is focused on intimidating Nevadans into silence. I work the polls a lot of hours. That's all I can tell you. And I was threatened by many people, but I stood up because freedom isn't free. So please, I ask my legislators also, Assemblywoman Brittany Miller and Senator Marilyn Dondarelou, please vote against SB 406, and let's all stand up and be courageous Americans again. Thank you.
Thank you very much for your testimony. Is there anyone else in Las Vegas who would like to testify in opposition? Okay, seeing none, broadcasting, is there anyone on the telephone?
Chair, there are no callers to testify in opposition at this time.
Thank you very much. We will close testimony in opposition and come to Carson City for testimony in neutral.
Good evening, Madam Chair, members of the committee. For the record, my name is Cadence Matievich, representing Washoe County. We are neutral on the bill, but wanted to thank the Secretary of State and his office for working with us, reaching out to county election officials for input as the bill was being drafted. And through the process, we particularly appreciate the clarification that's brought in the bill in subsection 5 of section 1 and in subsection 6, particularly with respect to defining election officials and close relations, as those are the individuals that are included in the bill language. Thank you.
Thank you very much. Is there anyone else who would like to testify in neutral? Seeing none, is there anybody in Las Vegas who would like to testify in neutral? Seeing none, broadcasting, do we have anyone on the telephone?
Chair, there are no callers to testify in neutral at this time.
Thank you very much. We'll close testimony in neutral. And please, Secretary of State, go ahead when you're ready.
Secretary of State, thank you all for listening to us today. I wish I wasn't here to have to discuss this issue. I wish we could live in a place where people were cordial to each other, understood, and supported our democratic process. But the situation, the reality is that we are here, and we need to ensure that we are protecting the individuals that are working our polls and running our elections. We could have all the technology in the world, we could have all the resources in the world, but if we don't have the human component, we're not going to see the elections we want as Nevadans. Nevadans deserve the best, and we're here to stand up for them. Thank you.
Thank you very much. Please hold for just a second. We'll close it again in case. With that, we will close the hearing on SB 406, and I believe Speaker would like to make a comment.
Thank you, Madam Chair. Given the hearing we just had and the lateness we are in session, I would like to waive our assembly standing rule that requires a 24-hour waiting period. So I'm formally granting permission to work session this measure out of committee this afternoon.
Thank you very much. And with that, we will open the work session for SB 406. Do we have any comments or questions on the bill? Okay, seeing none, I will entertain a motion to do pass.
So moved.
Okay, I think I have a first from Vice Chair Miller and a second from Assemblywoman Monroe Moreno. Any questions on the motion? Okay, seeing none, all those in favor say aye. Aye. Opposed, nay. Motion carries unanimously. Thank you very much, and thank you, Speaker. And floor statement, we will go to, let's do Vice Chair Miller. Okay, next on our agenda is public comment. Each person has 2 minutes to provide testimony. Written public comment may also be submitted to the committee up to 24 hours after the meeting. Is there anyone in Carson City who would like to give public comment? Maybe? Nope. Out the door they go. We will go to Las Vegas, seeing no one in Las Vegas. Broadcasting, do we have anyone on the telephone?
Chair, the public line is open and working, but there are no callers at this time.
Okay, thank you very much. With that, we will close public comment. Any comments from the committee before we adjourn? We have the softball game. Now, they said it started 30 minutes ago, but let's face it, we don't do anything on time here. So I think we have plenty of time to make it. Enjoy your evening, and we are adjourned.